Hey YouTube family and GN subs, how are you? Welcome. Hey, get ready for our live chat. It's going to be coming at you. And for those of you who are new to the channel, welcome. They call me Mr. Good News. Why? Because I keep things positive. I give you good news, right? Today I have great news, right? There's a new BIA case that came down that says USCIS, the government, they must provide you in the context of a marriage case with derogatory information that they're trying to use to have a permanent bar in your immigration file under 204C. Hey, this is big stuff, folks. We're going to unpack these cases, this important trend. It's brand new, November of 2021. Hey, let's get at it. All right, so what are we talking about here, right? There's a law called 204C. It is a permanent bar in marriage cases. Usually what happens, you have marriage number one, where immigration says that there was fraud. Then you have marriage number two, you file an I-130 petition and it's denied because of this prior case immigration found fraud. That's called a 204C bar. It applies not only to subsequent marriage cases, it applies to subsequent family cases. Like if your parent's a U.S. citizen and they want to apply for you, that case will be denied because of this fraud that immigration found previously. Second preference petition, third preference petition, even brother-sister petitions, even an employment-based petition, they will deny it based on 204C. So this 204C bar, it's a permanent bar. You are never going to get a green card. So I have a previous video where I talk about how you need to fight a 204C fraud charge. You need to look at that. I'll put a link in the description to that video. Check that out as well, all right? The second context in which this may apply, which I've been finding recently, is in the context of U.S. citizenship application. What's been happening if, again, prior marriage, subsequent marriage where the actual green card was approved, so this could be years later, right? Immigration in a citizenship interview, they're trying to find fraud on marriage number one. It's ridiculous. They have no evidence whatsoever. They're claiming that they have evidence when they don't have evidence. I have a recent case where they came back not only 15 years after that first marriage, but after 2 interviews for citizenship. The officer sends a denial and says, we have substantial and probative evidence that the marriage number one was fraudulent. That's not going to fly, folks. I'm going to tell you the cases. We're going to digest them today. There's no way that this is going to stand. It's over, okay? And yeah, so the first case that is very, very important in this project, I got about 4 cases that we need to go through. And these are the cases that you can use in your particular case, or tell your lawyer, because your lawyer doesn't even know this yet. But let's digest these cases so that you have a clear understanding of what we're talking about, okay? All right, the first case is United States v. Cardozo. This was a case back in 1987. This was our first flagship case where they talk about what evidence is required for a marriage petition in general, right? And what standard of proof does the petitioner have in connection with that case. So the standard of proof that the petitioner has is called preponderance of the evidence. What does that mean, folks? It means that it's more likely than not that the marriage is valid based upon the evidence that you provide. It is a very low standard. It's a low bar. A lot of people don't know that. And, you know, I always remind the officers in connection with my cases, it's a preponderance standard. It's more likely than true that this marriage is bona fide. So approve the case, right? And the law, subsequent law says that that USCIS must and shall approve these cases. So that's where we start, right? And I'm going to list in the description box a link of the citation of these cases. So you can actually just go on and Google them and you can read them in detail, okay? Second case, really important, matter of Singh. Matter of Singh comes along. And matter of Singh is a recent case. This is 2019, folks. Matter of Singh says that USCIS must provide substantial and probative evidence of a finding of fraud. What does that mean? We talked about preponderance of the evidence standard, very low. We talk about clear and convincing evidence, which is the highest standard. Matter of Singh says we're talking somewhere in the middle, right? So the government has to prove its fraud charge, right? It has to prove that it's more than probably true that the marriage is fraudulent, right? So this puts the onus on the government. Again, I remind officers all the time, if you're going to find, fraud here, it has to be substantial. You have to find it. You can't just, provide evidence that is not relevant, to such a finding. So again, Matter of Singh, important case, came along 2019, says the government has to prove their fraud case, okay? All right, and then comes along Ching versus Mayorkas. That was back in 2013, really important case, okay? What happened in that case is that they found that the petitioner, in connection with the marriage petition, they have a liberty interest. They have a due process interest. That's really important, right? What that case held was that there was a subsequent investigation after the first interview in that case, right? Sometimes these investigations can take place years after the actual interview. So in this investigation, the government alleged certain facts without articulating and delineating exactly what the evidence was. So the Ninth Circuit said, look, you need to provide this evidence to the petitioner so they can rebut this evidence. Really important case. What I find, I'll give you an example. So I have marriage cases where years and years go by, right? Marriage number one, years go by. Government is now investigating marriage number one. They finally get to it, believe it or not. Meanwhile, marriage number two is going on. Years have passed. The petitioner and the beneficiary no longer living together. In fact, they're divorced, right? So the investigators will show up to the house or apartment where they lived years and years ago. That's, again, marriage number one. And they'll go to the neighbor and they'll go with the picture. Have you seen these guys? And the neighbor goes, no, I haven't seen them. So subsequently, we get a notice of intent to deny, and in that notice of intent to deny, it says, oh, the investigators went to the neighbor's house at this address, etc., and they said that they never saw the beneficiary and the petitioner together. Okay. And they use that evidence, actually, even if you subsequently deny those allegations, they use that to deny the petition. Okay, I've seen it millions and millions of times. Well, with matter of Mayorkas, no longer an issue, right? You get to be presented with this evidence, right? And you get to rebut it, okay? Matter of Law-Zerezghi, really important case, came down in 2020. That case specifically said, and it cited the cases that I've just outlined, it said unequivocally, the government must provide derogatory evidence that it's using in connection with any fraud finding under 204C. Really important stuff, folks. Now, what's been happening is that the BIA now has been remanding these cases. I got one remanded where actually the government, USCIS, asked that the BIA remand it because they know they didn't have substantial and probative evidence of fraud. And so they're coming back, they're having another interview for the I-130, and again, they're trying to prove fraud. I had one the other day, and I told the officer my client isn't answering any questions in connection with marriage number one. We're here with marriage number two. He has 5 kids now. Approve this petition. If you have substantial and probative evidence of fraud, then prove it, right? All right, so in this BIA case that was just remanded, the facts are that marriage number one, the U.S. citizen spouse, submitted to USCIS a declaration, a complaint that the marriage was fraudulent, that first marriage was fraudulent, okay? And USCIS used that statement without providing it to the individuals in the second marriage, particularly the spouse, the U.S. citizen spouse number two, who again has a liberty interest, right? I mean, it's important that she's able to look at all the evidence that may have a negative effect on her case. So the BIA specifically remanded that case and said, provide evidence of the statement from the prior spouse. Okay, that's big. You can look at that statement and you can see if it's true or not what the government is alleging, okay? And that may have a substantial impact on your case and a finding of fraud. Moving forward, it's important, right? You're going to be able to request evidence that the government is alleging. That's huge, guys, right? That's a huge recent development. The government always alleges facts based on no evidence. They can't do that anymore. They have to provide you with the evidence. And when I say you, again, it's the petitioner, usually in marriage number 2, right? Because it's their liberty interest to have their spouse, beneficiary, be in the United States through marriage, okay? I've listed these cases. These are really important. Let the officer know when you're in the interview that you know these cases. They know that you know. It's going to help you. Tell your attorney, right? Most attorneys, this is just recent stuff, folks. The BIA just remanded this 2021. So this is recent stuff. Let your lawyer know, you know. I don't mind. I like to share information because I'm the good news guy. Hey, thanks so much, GrayLaw TV, GN subs. Thank you so much for tuning in. Look forward to our live chat. It's coming soon. Hey, thanks again. Give me a thumbs up, guys. Please subscribe. I give preference to my subscriber. Those who subscribe, I answer all of your questions in the comment section, folks. I take my time. I give you the details. I even have you sometimes give you my email address. Hey, you can email me directly, all right? So, hey, you guys, we'll see you next time. Take care.